Thanks for coming, guys. My name's Kurt Falkenstein. I'm from a law firm called General Standards. All we do is startups, hundreds of them a year. So we see people from all different walks of life doing all sorts of different businesses. A lot of people doing technology, but also a lot of people doing traditional business, cafes, restaurants, people starting building companies. We've had interesting ones. We've set up escort agencies, mobile strippers. We do the whole lot. So we see people in lots of various capacities of how they start businesses. We see people very well financially resourced. We specialize in helping people who are inadequately financially resourced. And everything in between. So during our life as a firm, we've really gotten to know what it takes to start a business, right? And what you need to do legally to make sure you don't need to come and revisit this beginning of life process. All right, cool. I'll get started. I'll stop. We've got a marketing agency in Los Angeles who do all our global marketing for us. So we have Instagram and Twitter and Facebook and all this kind of stuff now. It's only just started. So if you'd like to follow us, if you can take photos and tweet, I think we're on Instagram as well under General Standards. This is all very progressive for lawyers. All right. So we've got 60 minutes. I've probably killed a few of those minutes already. I'm going to run through structures and entities because I think this probably takes up a fair bit of time. I really want to get you guys up to speed with the various business entities that you're both going to use and come into contact with during your business life, so you know how to deal with them. We'll talk about the very building blocks you do of getting a company set up, what you can do to protect your IP, how to contract your team, how to contract with your customers and suppliers. Is everyone here thinking about people interested in raising money, external finance for their business? Is this something that, if I get a show of hands, if that's relevant, something you think about? Okay, I'll touch on it. Sometimes we get that and everyone puts their hand up and it's like they want 20 minutes on that, not 5 or 7. I'll try and do an example, and then just while I'm talking, there's questions at the end, but just put your hand up. I don't get thrown as a presenter, so please ask, because you'll probably forget by the time we get to the end. All right. Structures and entities. Can someone in the room tell me the difference between a business and a company? Okay, well, I'm going to tell you. A company is a separate legal person. All right, the only other way in life you can create a legal person is to have a child. So a company it's a legal entity. A business is an undertaking for profit. All right, so a business is an asset that any legal entity can own a business. This is some legislative restriction, but I can own a business. I can be out the front on Grattan Street, squeezing lemons, hustling them off. I could probably get $4.50 for my lemonade. That's me as a business. That's my asset. You want to buy my lemonade stand, you buy it from me. A company is its own independent legal person. I create Lemonade on Grattan Proprietary Limited as a company. We're out there hustling lemonade. We're charging GST and everything now. They're $4.95. All right. You want to buy my lemonade stand, you buy it from the company. What I have as the founder or the entrepreneur, I own the shares. So if you're going to start a company, the most important thing to realize is that what you will own are shares. You don't own the business. Right? So this is a major thing that a lot of small business entrepreneurs run afoul of, that they think that the assets of a company belong to them. Now, in practice, possession is 9/10 the law. That's not just like an idiom, it actually exists. If you're the sole director and sole shareholder of a company, you tend to have unfettered access to the assets and you tend to use them in a very personal manner. But most likely, if you're going to grow a company that has some degree of scale, if you're going to involve other business partners, then you're going to end up in a scenario where that distinction between legal persons is hugely important. And it comes down to one major thing. It's money in the bank. So if you run a company and that company has businesses and the company has cash that it's earned from its businesses, as the even if you own that company entirely, you can't just take that money out of the bank. I mean, you can. But that actually you don't have any right to that money. That money has to be paid out to you. And I'll talk a little bit further about how that occurs. But in common parlance, we use the terms company and business interchangeably. Recognize that, but just understand that they are separate things. And so when I use them throughout the topic tonight, they have distinct meanings. So I want to talk to you, I guess, about this whole thing's about companies. All right. So there are multiple ways. So maybe I'll work backwards. So like I said, if I'm out on the street selling lemons to make lemonade, I'm a sole trader. So anyone can do this. In Australia, to be a sole trader, you go to the ATO, you get an Australian business number. It happens basically automatically. You're in business. All right. Now, this works if it's just you. The problem that exists with a sole trader is that if my lemons poison someone, all right, and they die, it's my business. The business is me, and I now owe that person, I owe their estate, their family, compensation for having poisoned them. Now, you can imagine if you were going to go and build a mine, all right, and there's a whole heap of risk and a whole heap of expense. I need to go and get $1 billion from the bank. The bank's not going to give me personally $1 billion, and I'm not going to take the risk of I might have tens of billions of dollars of potential liability if I get things wrong. I can't handle that risk myself. So the major problem with being a sole trader is if something goes wrong, it's all your fault. Nothing you can do. I mean, you can have an insurance to cover it, but it's all your fault. A partnership is basically two sole traders that come together. And I'll explain why this is really important for you guys to remember when I'm talking about IP protection. All right. So as a partnership, it's just two sole traders, three sole traders. So it's the individuals come together. A partnership, right, is not an entity. It's a relationship. So the partners might be collectively called, the ABC partnership, and they will have a collective ABN. But the way that any assets, the business of the partnership is owned, it's owned jointly without any possible separation by the partners. The only way the asset can be divided up is by dividing up the partnership. All right. Now, partnerships have a degree of flexibility. Just like if you're a sole trader, the money comes in and out is yours. But in a partnership, not only do you have this fear of being unlimited, having unlimited liability for your own actions, in a partnership, you have unlimited liability for your partner's actions as well. So if one of your partners does something crazy and incurs, on behalf of the partnership, $1 million worth of liability, all the partners are jointly and severally liable. So in the context of liability, partnerships and sole traders put a huge handbrake on undertaking business because you just got too much risk. That's why we have companies, all right? The major feature of a company is because it's a separate legal entity. It's distinct from its shareholders, so that the shareholders, all that they have at risk in the activities of the company is as much money as they've put in. So if if there's $1 million worth of capital that's gone into the company via the shareholders, that's all that they can lose. The company can't incur debts and then the company's creditors go and chase the company's shareholders, right? Because there's a legal separation. So the concept of shares and the limitation of liability is what makes the company such a great vehicle for running a business. It's because you can you can chop up the company very nicely, all right? You can create shares. You can then allocate those shares to people. The company can get money from the company. Effectively sells little bits of itself. It's incredible. It's like an organism. Instead of having cells, it's got shares. It just keeps cutting them up and selling them off and getting more money. It's an unlimited amount. And it's got an unlimited capacity to do so virtually. But the big thing is that then so the shareholders. So this is where the concept of the company came about, is because there's too many things you need to do to drive commerce forward that have too much risk that individuals don't want to be liable for it. You know, you can imagine if you're in, you know, so it's the 1600s in England and you want to put some money into finance a venture to the East Indies to bring back spices, right? Well, you don't want the whole ship to go down or the ship to run into another ship, even worse. And just because you happen to be a lord and have a whole heap of land and castles and men and fields and all the rest and gold, that they just come and sue you. Why sue the people on the all the poor people? Just go straight after the rich person. Without the concept of limited liability, it fundamentally disrupts the efficient allocation of capital into projects. Otherwise, the capital providers are stuck with too much risk. But you can imagine if you've got this concept of limited liability, problem is, well, then the company's got this ability where it can go and do the wrong thing by everyone and no one is personally responsible. And we've all seen it, we've all heard about it. And so therefore, in Australia, what we have is we have company directors, right? And the company directors have got a set of responsibilities. And so my challenge to you as would-be entrepreneurs and current entrepreneurs is to understand that when you are in the business, when your business is running companies, your profession is a company director. So entrepreneurialism, that's a spirit. That's a type of activity. All right? You can be incredibly entrepreneurial and have nothing to do with companies. But if you want to run a company, you've got to be a company director. And being a company director is being able to utilize all the benefits that a company will give you, right? And manage the responsibility that the individuals who run the company have to have. Because, you know, commerce won't work and society won't work if everyone can hide behind limited liability. So as a director, you got to remember that your responsibilities are just as severe in a startup as they are if you are if you're the managing director of BHP. You've got exactly the same responsibilities. The major reasons why people, the major reason why directors get into trouble is they don't manage the finances of the business properly, and as a result, they cause other people to lose money, which is predominantly creditors. So the company's out there doing business, losing money. It can't pay its bills in time. So you cannot trade a company while you're insolvent. Insolvency, is really important to remember, is a cash flow issue. It's not an asset issue. So, you know, basically you'd think if the company's got more assets than it does liabilities, it should be okay. But on a cash flow basis, if it doesn't have sufficient liquid assets to pay its bills as and when they fall due, that's the technical description of insolvency. So as an entrepreneur, you know, you're responsible, you're out there trying to create opportunity, you know, you're always hustling. But as a company director, you've got to take responsibility for the company, because if you trade the company while insolvent, so if the company can't pay a bill and you continue to incur debts on behalf of the company, you might have to pay them yourself. Now, the typical way that this happens is if you don't pay your tax, the company doesn't pay its tax. Particularly if you don't pay the tax that you have to hold back from your employees when you pay them every week or every month, that's supposed to be remitted to the government. Because the government says that's not to the directors, that's not the company's money. That was the employees' money, actually. It's not even, you've already given it to the employees, and now you're supposed to hand it over to us. So if you're not holding on to it from the employees, you're holding it on to the government. And if you don't have it, well, then you've done the wrong thing. The other side of it is occupational health and safety. If directors of companies could just completely ignore the rules related to workplace safety, they could tell people, hey, could you climb up on top of that light there and fix another light bulb? Oh, you fell over. What are you going to do? Sue the company? It's got $2 worth of capital. We'll start another one. Yeah, that doesn't work. It doesn't work. It's unfair. So Australia's got an extraordinarily advanced corporations law, and very well advanced workplace relations laws, and so things like that become the director's responsibility. And so a good company director knows how to utilize the benefits of limited liability and be the benefits of a company by being able to split up its capital, divide shares, to be able to go and create an enterprise, but know how to do it in a manner that doesn't put them at risk. You know, it's like being out there on a horse. You mean, like if you know how to ride a horse, you know it's extraordinarily risky, but you can have a lot of fun. You know, if you get on a horse and you don't know what to do and it starts galloping, like, I'm being recorded, I can't swear, but it's a bad place to be. All right, so, but an important thing to remember is when it comes to a company, how the hell do you get money out of it? How the hell do you get money into it? These are important things. So basically, there's only two ways to get money into a company. Either it's applied as it's capital, you contribute equity to the company, so you buy, shares are bought in the company. The company sells shares and people buy them, the company keeps the money. There's an important distinction to remember actually. You know, in startup land, you know, you got a company, you want to get money into it. The company sells shares. You know, they're the company's. They're not the company's asset. They have an inherent right to issue shares. Once you own the shares, if you sell shares, the money comes to you. So if you've got a startup and you want to bring people into the startup, and they're going to put money into the company, like as an investment in the company, not buying shares from you, the company issues shares, not you selling shares. It's an important thing to remember, because I just know from the volume of people that come into our firm and said, oh, we've got 100 shares in the company, I'm going to sell my friend 5 shares, they're going to have 5%, and they're putting $50,000 into the business. Which is what doesn't really, you know, the right way to do it is the company issues shares. So I'll talk about this in your foundations, but that's why when you're in the early stages of a company, particularly if you ever get some investors that want to put money in, it's very important that what authorities are needed in the company to issue shares is a critical decision that needs to be made. Because if you say that, you know, if you get an investor in and they say, I want it, you have to ask my permission before you issue any more shares, that can totally stymie the company. Because if they say no, there's nothing you can do, you can't issue any more shares. It's the primary means of getting money into a company. The other way of getting money into a company is a loan, right? And so if you're starting a company and, you know, you buy a laptop and you know, you do a bit of marketing, $500 here, $1,000 there, that kind of thing. Typically, you're going to be lending that money into the company because that means it's flexible. That way, when the money comes back out, it's just repaid to you as a loan, so that doesn't go towards your income. If you put money in as capital, the only way you can get it out is as a dividend. The only way you can pay dividends is if the company has got retained earnings. It can only have retained earnings if it has made profit and paid tax, or at least incurred the tax liability. So you can see that getting money in and out of a company can be more difficult. And that's sort of important because the company doesn't want to be able to, because it's its own legal entity, it's trying to grow its own wealth. So it doesn't want to be stuck in a position where a shareholder or a director can come in and just yank all the money out, like can happen in a partnership or in a sole trader. So typically, as a founder, you know, and the way you're going to get money out of you start a company. The way you're first going to get money out is firstly as a salary, or you get some payment for services, director fees, that kind of thing. And then after that, you're going to get, when the company's profitable, you're going to get dividends, which is obviously a proportion of the company's leftover profit. Most companies don't pay out all their dividends. You know, if you've got a business you're going into with some friends or whatever, and you really want to get all the money out like every week, you know, just pay it all out, effectively just clear the slate, pay everybody off. All right, there's $100 left, we split it all and we start again next week. A company may not be the right structure for that. Typically, businesses that run like that are smaller businesses. Nothing wrong with it. I mean, like, you know, encourage everyone to be involved in as many businesses as is, you know, sensible for what they're doing. A type of structure that you'll run into regularly in Australia is a trust. So a trust comes from an area of law. It's called equity. Anyone here from law school? So I can bore them. They can. Oh, great! No one can challenge me on any of this. I can lie. No. So anyway, so trust comes from the law of equity. Most things comes from common law. Equity's there designed to create fairness. What a trust does, and what a trust does, trust is a separation of ownership. All right. So basically, it comes to the fact. So I'm going to die. I'm very wealthy, and I have infant children, and so I say, but I can't leave the wealth in my estate to my infant children, and so I'm going to appoint, Fred to be their trustee and to look after all these assets as they see fit, and to hold them on trust for the benefit of my infant children until they're sensible enough to do it, to look after themselves. This is where the concept of trusts come from. Right? In contemporary use, so like now, they still get used in that sense. But in business, you'll find, so what a trust does is a trust has got a separation of ownership. So I'll talk about it first in the context of how you guys might own shares in a company, right? Then I'll talk about how you actually can use, like as a trading structure, as an entity that, as a relation structure that owns a business and can trade, and why that's important to check out. So if you want to own shares, if you're an Australian resident, you think you can live in Australia, and you want to own shares in, well, basically in any, whether it's an Australian company or a foreign company, using a trust is a great way of doing it. What does a trust separates ownership? Everyone have heard, if you've got assets, you want to get them out of your name. Rich people have things, oh man, you sue me, but I don't have any, I don't have any assets, That's what these are. This is what a trust is. So a trust, you have a trustee or trustees. That's either a separate company, separate legal entity, or separate people, normally yourself and someone you trust, a sibling or a spouse. And the trustee owns the asset, the shares, on behalf of the beneficiary, which is typically you and your family-related companies and trusts. This has a big benefit. So if you have a personal liability scenario, then that person can't seize the shares from you, right? Even though you got the benefit of them, in the end, any value that comes from them will come through to you. The legal title is in someone else's name. So it doesn't matter anything. Like if I have, this incredibly handsome light projecting machine, I'd say I would like Alex to hold this on trust for me. All right? In fact, don't give it to anyone else. I just want to be the only one that can use it. But if someone wants to buy it from me, they have to have the contract with Alex. So that's the way it works at law. If something else, if one doesn't have legal title to something, someone else can't get it from them. You mean you need legal title to be able to convey ownership, and the trust separates the legal and beneficial interests. So why would you do this as a shareholder? Big one is asset protection. All right, that's great. And as if bad things didn't happen to people, if the rainy days didn't occur, there'd be no need for lawyers. Do you mean our whole job is about preparing people for when things go wrong? So I'd be quite happy to be out of a job, put it like that, though. I'd rather see everyone happy. But the major reason you actually do in Australia is to minimise tax. Right? People say to me all the time, why would we bother setting up a trust now in the beginning? Why can't we do it later? The answer is tax. People say to me, why do we put this structure in place? And tax. Why do we do this type of business? Tax. Unfortunately, when you're engaged in commerce, half the reason you do or don't do things, particularly on a corporate side, on a structuring side, has got to do with tax. It's insidious, but it's like death. It's omnipotent. But the reason you want to use this to your advantage as a shareholder, is that if you have what's called a discretionary trust, otherwise known as a family trust, own your shares. It's got this wonderful ability. The trustee has the discretion on where to apply the income and capital of the trust. So if you've got, you receive $100 through this as a dividend from the company, you receive the $100, all right? But your tax bracket's quite high, and you're going to pay a lot of that $100 out in tax. You can put that $100 out to your mum, dad, brother, sister, child, park some in a company, put some in another trust to create the cycle going again. This has the benefit that if you're making a lot of money, if you're making anything above $180,000 a year in receiving in dividends, has the ability to effectively get your tax rate down towards 30%. So if you're receiving money as an individual and you're in a low income tax bracket, take the money out of your company as salary because you'll pay less tax. So you've got to look at, as you go up the tax brackets in Australia, what's the most effective rate you can be in. So with a discretionary trust, you can stream the income that you receive into lots of different areas. And hopefully you can go into entities, at least if nothing else, you can park the money in an entity that's got a 30% tax rate. Because say you have 1 year and $1 million pops out, right? And your tax rate is 49%. Well, you're going to lose half of that money. It's going to be gone. So at least if you can stick that money into a company and then use it in a year where you've got a very low income. The fact is, though, as a entrepreneur, if you founded a company, a trust, a discretionary trust, will be the linchpin in what you use to manage and grow wealth. If you don't put it in place at the start of your business life, at some stage you're going to get convinced that you're going to need one because you're going to go, look at the tax you would save, that's what you think. But the reason why you do it in the beginning is because you get a lot of benefits, like from So the difference, if you own the shares yourself, you get sued, they can come and take the shares off you. All right. Any dollar, as soon as you have a right to income as a result of your share ownership, you got a tax event. You can't get rid of those two things. So the benefits of a trust are like really apparent. So if you start with owning shares in your own name and then you want to go and get the benefits of the trust, do you reckon the government just lets you do that? No, they tax you. Because if you're moving anything of value virtually between two entities, it's called a capital gains tax event. Doesn't matter whether you've like made money or two. If you've lost money, you get a capital loss and you get a credit against any further capital gain. But typically, if you start a company, it's worth nothing. It's not even worth the paper you printed it on. Then 5 years later, it's worth $5 million. And you say, well, I want to move my shares into a trust now because Christ, if I get sued, it's going to be bad. And hell, I'm making tons of money. I need to save some tax. If that's worth $5 million and you move that into a trust, you get taxed on that capital gain, $5 million. But you don't want to sell the asset. You're just trying to protect it. You know? So on that basis, that's why that movement into a trust is you don't get any tax relief for it. So as an entrepreneur, if you're going to stay in Australia, a trust you're only going to do once. You do it once in your life. And you'll use that then to own the shares that you own in multiple companies. It's a very sensible thing to do. You won't find, the only reason lawyers and accountants maybe recommend that you don't do it is perhaps because they charge too much for it. You should be able to put one of these in place for a couple of $100. It's the best couple of $100 that you'll spend, particularly in like 10 years time when you can look at, so put it like this, I had some clients, guys I've worked with a long time, good buddies of mine. We put a structure in this place when they started their business. Last year, they had an extra $462,000 between them because there's three of them because of putting in place the trusts. That's a lot of money. You know what I mean? Like that's a house. You know, one of them wanted to spend money on a Lamborghini, but we talked him out of it. But that's the kind of difference that it has. You know, that was on just under $1 million of earnings each. So you can see so that's on say nearly $3 million worth of earning. That's $462,000. You know, that's a 12%. I'm not good at math. I went to law school. That they've been able to keep back. It's very much worth doing.
How costly is it to maintain?
To maintain, it costs no more to maintain than doing your own personal tax. If you have a company as a trustee, you might have company registration fees like $250 a year. The accounting fees, it's just another entity that needs to be accounted for. So if you own the shares yourself, you've got a lot of money coming in, you'll have a more complicated personal tax scenario. I have a trust, it cost me less than $1,000 a year, and that's because I've got full accounting on it. So it's not complex.
So to be clear, is that if you're a director and your shares are in the trust?
Yes.
And you get sued personally?
Yes.
They can't take the shares in the trust?
That's correct.
What if you're a trustee of the trust?
So we recommend that you don't act as a personal trustee. You should always have a company as a trustee. But if you are personally the trustee, you don't have any the trust doesn't have personal liability for you. The fact that you are a personal trustee of this is where it gets complicated. So in trust, you imagine if you've got both the legal title and the beneficial title, there's no trust. You can't hold something on trust for yourself. So in our practice, we don't recommend or allow any of our clients to be the sole beneficiary of a trust in which they're the sole trustee. So you need to have a co-trustee, because then it's not yourself as a trustee, you're jointly trustee with someone else and you jointly own the assets on behalf of the beneficiaries. Or better still, use a company as the trustee and then you got no problems. It's very clear and distinct that it's a separate legal entity.
But you own the company, so...
Yeah, but a company is a separate legal entity. It doesn't. So the fact that you own it doesn't really matter. So what you will own is you would own the shares in the trustee company. They sue you personally. Say you owe us $1 million. You go, well, I've got one share in a company that's a trustee company. It owns no assets in its own right. What do you want to do? Be the trustee? Knock yourself out. The appointor of the trustee, who chooses a trustee, which will be you, will be like, I'm now firing you as a trustee. You can keep that company. I'll get a new one. There's a reason why, and this is the important thing. So a trust can also be a business, because a business is an asset. So the trust can own, so you can say you can create a trust, have a company as a trustee. The company doesn't own the trust, it owns it on behalf of the beneficiary. So now it's in this trust relationship. This is super important to remember in business. So all these things, all this stuff, you can find it on the Australian Business Register. You go to abr.business.gov.au, or you go to asic, asic.gov.au, and you can search all the business entities and all the company entities in Australia. Finding about information about companies and business in Australia is fabulous. You know, doing it in the US is incredibly difficult. Go and try and find the details on on just a small business in the US. It's very, very difficult. There's, how many states are in the US, Spencer? 50. So there's like 50 different corporate laws. There's 50 different offices at which you can register a company. There's 50 different naming, protocols. So, finding information, in Australia it's just one. So you've got no excuse. So a trust typically, why this is important is because in Australia you get a business name. So you get a business name, Fred's Flowers, all right? And if you get Fred's Flowers ABN, the ABN will typically say it belongs to the trustee for the Fred's Flowers Trust. Now, if you do business with Fred's Flowers and they owe you $1,000, you say, I'm going to sue Fred's Flowers. All right, cool. All right, who's the trustee? A trust deed is completely private. It's not on the public register. So when you go to do business with people, always check their details. For every single contract that we do, hundreds of them a month, we check every single entity and check their ABN, Australian Business Number, or if they're a company, their Australian Company Number. We make sure we find out exactly who the entity is, right? A couple of good reasons why. A company, to be bound to a contract in Australia, if it's got more than one director, it requires at least one director and one secretary. So typically 2 directors of a company to make what they've said binding. If it's a partnership, it can just be one partner. It's a sole trader, it can be one partner. But if it's a trust, you need to know who the trustee is. So you need to know, is that an individual? Is it joint individuals? Is it a company? Because if you don't know that, you try and sue this company for money, the court can't help you. You say, I sue the trustee. They go, who's the trustee? And you say, well, can't you help me find out, court? They say, no. You can't even commence an action. It's something we see all the time. People can be very sophisticated with the way they use business entities to deceive people and defraud people. Don't be one of those people. So if you've got a company acting as the trustee, you own, the trustee is liable to settle the debts of the trust with the assets of the trust, because the trustee controls all the assets. They're in the trustee's name. So if you are the company and you're acting as a trustee and it gets sued, it has to pay out with the assets. So typically, if you've got a trust that owns shares, you don't use that trust to go into business. You don't start selling lemonade with that trust. You don't start buying cars and stuff with the things that are risky, because you want to use the trust that you own to get rid of, so what the shares that you own have got no risk associated with them. That trustee and that trust relationship does nothing. It kicks back, owns shares, get rich, get fat, doesn't talk to anyone. Very, very lazy, very selfish. Then if you've got other activities that are customer facing that incur risk, that's where you actually want to, then you want something separate then, so you're going to have a trade to minimize your risk. Where are we at time-wise? Wow, is that like, I told you this is like most of the lecture. So does everyone get it? Like, picking your structure and knowing about structures is so important. I won't lie, it's surprising to us as lawyers that there is there's a low level of literacy in regards to companies, trusts, business structures, which is a shame because you have to deal with them every day. So, if you want, there's tons of reading information. Now, this is building blocks, corporate law. You can read all this. I don't think there's anything I told you tonight that probably isn't on Wikipedia. It's all there. So do spend the time learning more about companies, trusts, partnerships, and sole traders, because it will carry you in good stead. Now you know all this shit about companies and trusts and stuff. What do you actually do to kick things off? Anyone here contemplative of going into business with other people? That's nice. I'm glad to see everyone else as solo entrepreneurs. I respect that. All right. A lot of this, so I want to give you some stuff that you can take away. Getting documents signed is really hard. All right. Settling how you're going to be in business with other people is a challenging task. It requires uncomfortable conversations. A good, robust conversation will also contemplate parting ways. All right. But because you need to get to a signing moment, I can encourage you, if you're going to form a company with people, you really want to try and set the creation of the company or the receipt of shares in the company as the incentive, as the milestone that will occur once you settle all this stuff. Quite often people create a company, issue the shares, do all that stuff properly, but they don't put in place like the documentation about the shareholder relationships. They don't use, they don't settle the foundations amongst themselves. There's very few other motivating circumstances there to then sign those documents. Oh, everything's fine. We're making money. It's all good. If you're one shareholder, how can you force your other shareholders to sign? Anyone know? There simply isn't. There's no way to compel. You can't sue them and say, you were supposed to sign this document. No, we weren't. Because you can have a company without a shareholder agreement, operating in the vanilla sense. Our corporations law in Australia is that good. If you start a company, it doesn't have any rules how to run the company, it just puts them in there for you. So you can't even get it wrong. You can't have a gap in a company that makes it invalid. It's a great law. But as a result of that, you can imagine a very vanilla type company does not give shareholders themselves the kind of protections they want. It basically puts all the discretion into the directors of the company and some very few protections into the shareholders. Basically, you want to change the company name, the company wants to cancel shares, it requires a special majority vote of 75%. So if you want to set things up your own way, and trust me, if you're in business with other people, I see very few people use vanilla companies. They do want to have something different. They say, well, if you want to sell your shares, I want to buy them off you first. You can't go and offer them to our competitors. I want to be able to buy them. I don't want to be able to be kicked off the board. I started this company. I want to make sure. If this company goes bankrupt, I want to make sure that I can buy back all the IP and carry it on. These are the things that very common things you might want to do. They don't exist just naturally in the corporations law. So getting that stuff in there is absolutely imperative. A big thing to think about when you incorporate, and actually before I move on to this, I'm going to talk about something because this is what I got chastised for not talking about last thing, so I should probably put in there. So if you are creating a company and you want to secure people to participate in it for a period of time, say, yeah, we're going to go into business together, we're going to grow this thing, we're going to be the next Google, or we're going to be the next Harry's Fish and Chip Shop, doesn't matter. But you expect to work together for a period of time, right? So you give each other shares in the company, that's all great, and then your business partner disappears the next day. They've been abducted. What do? Do you carry on the business only owning 50% of it? So there's this concept we call share vesting. And if you're starting out a company, or if you're doing anything where you're giving up some equity in a company in order to secure someone's services, you need to have them on the hook for it. So you need to have them you need to have a right so that if they walk away, those shares can be taken back. If you read your startup blogs, that kind of thing, you see share vesting. If you've looked at it in Australia, there's a huge tax issue. And I'll just highlight this so you're aware of it. If you receive shares for providing services, the value of your services or the value of the shares or the market value of the services is taxable. So if you've got a company that's worth $1 million and someone says, listen, come in, kick a bit of ass for us, make a few sales, and we'll give you 10% of the company, you take that 10%, that's taxable in the year you receive it at your personal tax. That goes onto your personal income. So you get 100,000 worth of shares, you already made 100,000 that year, all of a sudden you got $200,000 of income, maybe you got a $60,000, $70,000 tax bill, but you only got 100 grand in cash, and you already paid out tax on that. Where do you get the other amount of money to pay tax? You don't, you got shares, you can't sell them, they're in a private company. So this is a huge issue that we have. The government tried to stop people getting paid in shares to avoid paying income tax, so they put this law in place. But this really makes it hard for startup companies that want to incentivize people by giving them shares. You know, so we've got a little bit of money, but we can't give you a full salary, we'll give you some ownership. So you give someone ownership, now all of a sudden they possibly have this tax issue. So what you want to do is, particularly the later you go. So if this goes, you know, so if you were to say, we want to give you 10% of the company over 4 years, so we give you 2.5% per year. On day one, it might be fine because the company's worth nothing, it's only worth paper. But in 4 years' time, if it's $1 million company, that person might, you know, they'll get taxed on the shares that they receive. So typically what you do in Australia is you issue, if you want to give someone an equity incentive, you give them all the shares up front, but they have a condition on them that if they don't do what they say they're going to do, either the other shareholders can buy them back. The company can also cancel them, but doing a share cancellation in Australia is a complicated beast, and getting it wrong can expose you. So if the shareholders just buy it back, it makes it simple. But it's a really important thing to think about as entrepreneurial people, because if you are entrepreneurial, you will expect that you can inspire other people to join you in an entrepreneurial endeavor with the promise of equity and building capital through your hard work. The worst thing that you have is that you do that, you then put heart and soul into that person and something goes wrong. Because equity is like a marriage but no divorce court. If you're giving away equity, it's personal property. You know, that's like something back, you get paid $50 and you walk in the street and goes, hey, I want my $50 back. Well, for what? Changed my mind. It doesn't happen. You can fight that guy if he tries to take your money, you know. So it's the same thing just with shares. So, you know, where you choose to incorporate is important, but also once you've incorporated, the IP that you want to get into it doesn't just magically unfold and end up in the company. You actually, intellectual property needs to be formally assigned. You know, if you were to say to me, if I was to say, hey, you can keep my copyright from this lecture, I won't sue you, you can say it's yours, cool. And then I see you doing it, and I come up and I'm like, and this wasn't on camera, I'm like, man, that's my copyright. You're like, you gave it to me. No, I didn't. Prove it. So, well, I can prove that I wrote it. I prove that's my intellectual property. Can you prove I gave it to you? No. So this is the same thing with intellectual property. Intellectual property just doesn't automatically transfer. If you want to get IP from someone into your company, right, you need to do it formally. Because the problem is, if you can't evidence the receipt of the intellectual property, you can't prove it. And because you want the IP so they don't infringe on you. They don't take the IP and do their own thing with it. You need to do something formal. So you need to convey the IP in writing. It's a really important step that a lot of people forget about when they create companies, because it's the founders in there and everyone thinking they're all building, but they've actually never done anything. They've never done the mechanics that gets the IP into the company. And so in terms of an incorporation process, we'll typically do the IP in last, because at that point you're going to say that's when the company's got, and there's no argument that the company has some value. It now has this IP that it can go and execute upon. Some simple things when you create a company. So cloud accounting makes life so simple. So the best thing you can do, get an ABN, you get that from the ATO, costs nothing. Open a bank account, open a separate bank account, costs $10 a month, and get a cloud accounting program. All right, get Xero, Sasu, MYOB Online, I don't care. I think you should use Xero. You should buy it from me. But the advantage is these days, if you connect a bank account to a cloud accounting system and you pay all the company expenses and you receive all the company money in that account, the cloud accounting system records all the information for you. You no longer take a stack of receipts into an accountant, right? So you're 90% of the way down there with financial management. If you don't have any financial management in place, how can you effectively dispense of your director's duty to run the finances of the company properly? If you can't look at something and know that you're solvent, how do you actually know that? Failure to keep proper records is a major reason directors get in trouble, because they say, oh, the company was solvent when we entered into a 10-year lease at $100,000 a year. So, well, how'd you know that? Oh, it was a bank account. Yeah. Well, you get a set of books. I know this stuff. Sure, you're liable for the $900,000 of rent you haven't paid. So, but it's just, that's a practical tip. It's never been easy. When I got into business for myself 6 years ago, it wasn't that easy. You still I actually started a business scanning receipts for people. Yeah, it was really exciting, you know. Lots of girlfriends, they were just falling over themselves to try and get a hold of me, you know. The old receipt scanner. That doesn't exist anymore. Not that business, nor that necessity. If you capture everything electronically, you know, you're basically there. It's such a practical. A lot of people don't do it. You know, people still perceive law and finance and accounting as complex, mysterious beasts. The reality is that they're not. The reason why things like MAP exist and get people like me in to do this is it should be part of the education. If you're going to be in business, that's a very normal thing in life to do. And so understanding these basic legal and finance things is, you know, it just solves. If you get it right in the beginning, you'll just save a whole heap of problems because you won't need to go back and ask a lawyer or an accountant to fix something for you. I've got a philosophy, which is when you give your problem to a lawyer or accountant, you double the problem because now they've got the problem too, plus your expectation that they're going to fix it for you. So if you can take a bit of a karmic approach to it all, you're making problems bigger by handing off these silly little problems. I shouldn't say that. By handing off things that you made a mistake in the beginning, because they can compound. We see people who didn't do this stuff, and they're like running multi-million-dollar businesses, and then it all just unfurls very rapidly because the foundations weren't built right. You know, the adage of building your house on strong foundations. You know, if you're choosing to make a decision to build wealth through business as opposed to buying property, build your house on a strong foundation. So I'm just going to quickly talk about IP, and then I might cut it and then let people ask questions. You can grab me afterwards if you've got specific information. Because I think IP will answer your question in particular. So obviously if you're creating business in this day and age, chances are you've got a big dependence on intellectual property. All right, that a lot of what you do, your competitive advantage is based on intellectual property, your know-how. You've got a technology set that you're exploiting over and over and over and over. It's important to remember that not much IP can be protected on a register where you can turn up and go, this is my IP, it looks like this precisely, and someone puts a stamp on it and goes, that's yours. So you get that when you have like a trademark, you know, you got your logo, your name, you get protection on it in a particular class of goods and services. So that's great to register. Patents, the same thing. So you patent something, you can articulate it in a manner that demonstrates its novelty. They accept that that's what it is, put a stamp on it, you can then exploit it to the exclusion of everybody else in the country for a certain period of time. The bulk of the IP that you'll create in your business is unregisterable. And it's the thing that people forget to protect. It's how you do business. It's the little thing that you do that gives you 39% margin in your business instead of 31. That makes you an industry leader and an industry minnow. You know, it's your hiring process, how you interview people to get the best talent into your company. You know, it's how you market. You know, it's where you acquire web traffic from. You know, it's all these various things that you want to, you know, you really, you know, make them sure. But people forget to protect. They don't protect it from their employees. They don't protect it from their contractors. They don't protect it from their shareholders. You know, so you know the best way you normally do this is one by getting IP assigned into the company, so the company's got a very clear right of ownership, and using confidentiality agreements or NDAs, often called non-disclosure agreements. Part of the problem is that using confidentiality agreements, using IP as something that can seem quite formal and officious, and people don't do it. And people do it at the wrong time. A confidentiality agreement is not a generic document. People treat them as generic documents, right? It's a, you know, I'm not going to swear again, but as a lawyer, it's extremely frustrating for me because we see people who say, I didn't want to use a confidentiality agreement because it was too complex, I didn't use it. Then we see other people who use confidentiality agreements and the subject matter that they're trying to make confidential, they'll give like a, you know, a business due diligence, you know, confidentiality agreement to someone they want to talk about an engineering thing with. Just completely the wrong subject matter. The most important thing, like intellectual, like tonight, I can't give you answers. I can sort of point you in the right path. What I want to encourage you to remember is that these things, copyright, as you know, exists automatically. You get copyright. You create something in a reproducible format, you get copyright. Trademarks, patents, designs, you can register. But the rest of it is up to you to be responsible with. Because too many people we see coming and say, this person stole my idea. Oh yeah? That sounds pretty shit. What happened there? Oh, I told them everything I did. Oh, okay, well, what do you think? That's a great idea. I wish I was doing it as well. Now we're your lawyer, I can't. We actually encourage a lot of people to not use confidentiality agreements because it can give a false sense of security as well. It's knowing how to articulate the important things about your business without giving away the secret sauce. And as a good company director, you can do that. You have to excite people. You have to make them want to be involved in this, want to do it. But you can't give it all away. And when you do need to give it away, you need to protect it. Because in this day and age, with where competition is so close to each other, and competitors iterate very closely to what each other are doing. If someone knows about your process, imagine if your competitor knows about your interviewing techniques and they hire the person that you could have got, and that person turns them into $1 billion company. That's the kind of risk that you face if you don't protect your IP. All right. So in terms of your question about dealing with the technology, about the university, it will depend on the terms of, on what your arrangement is with the university. If you're allowed to take the knowledge and use it, if they said that, that you might need permission to commercialize, they might not be able to stop you. You might have, you might just know things, you're not compelled, you might have a great idea based on your subject matter, but it's not part of necessarily your research. You're not compelled necessarily to hand that over. So typically most of these things don't have black and white answers, they got grey answers. And so if you're in a position where you are under a contract and you've received information, you're wondering what you can do with it, you've got to go back to the contract and take a look. But remember, IP doesn't assign just automatically. There has to be some clear thing that moves it across. So normally the slide after this is about contractors and team members. So I'm going to leave you with two important things, all right? Always make sure that if you have a contract with someone or a relationship where someone's building something for you, they're producing IP for you, they're doing something that's creating IP that you want to get a hold of, including your customers using your application. So if you want to run big data or you want to run analytics on your thing, own the outcome of the input of information into your product. Similarly, if you want to build a company of value, where do you get your money from? It's your customers, right? You can have the best thing in the world, no one buys it, it ain't worth anything. So if you ever want to sell your business, the company wants to sell the business, or as you as the shareholders want to sell off the whole company, you need to be able to transfer the value in your agreements. If you're acquiring technology, if you're licensing IP to put into another product that you're off selling, if you change ownership, you need to be able to transfer that value with you. If you've got 100,000 customers, everyone's paying you $20 a month, all right? You need to be able to assign those contracts over to a new purchaser without kind of having to go back and ask for 100,000 permissions. So assignment, the movement of value in business is critical. And if you remember something legally is knowing that where you're creating value, the more control you have about moving it, all right, is a great way of being able to exponentially increase the value of that in terms of dollars in your pocket at some stage. So on that basis, I'm going to wrap it up because that has been about an hour and a bit. Cool. Thanks, everybody.